Hello and thank you for tuning in. This video is designed to give quick overview points of the Bribery Act 2016 to sensitize and encourage establishment of ethical code of conduct and culture of best practices. First, let's dive in and define what bribery is. A bribery offense is committed when a person offers, promises, or gives a financial or other advantage to the other person receiving who knows or believes the acceptance of the bribe would itself constitute the improper performance of a relevant function or activity. The Bribery Act 2016 applies equally to both public and private sectors. The Act mandates all sectors to adopt bribery prevention procedures and to report any knowledge or suspicion of instances of bribery. The Bribery Act makes it mandatory for all public and private entities to put in place procedures appropriate for prevention of bribery and corruption. Failure to put in place such action is a criminal offense. Responsible persons are liable on conviction to a fine or imprisonment or both. The Attorney General published Bribery Act regulations and guiding principles to assist public and private entities to understand as well as prepare procedures for prevention of bribery and corruption. Kindly familiarize yourself with the array of detailed regulations and guidelines. Any person holding a position of authority in a public or private entity is mandated to report to the Commission within a period of 24 hours any knowledge or suspicion of instances of bribery, failure to which is an offense. It is important to note that the regulations give clear methods of reporting bribery, mechanisms for internal and external reporting, ensure the confidentiality of information, and protection of whistleblowers and witnesses. The Act makes provisions for protection through the Witness Protection Agency of whistleblower informants or witnesses from intimidation or harassment arising from providing information or giving testimony against bribery. A whistleblower or a witness is entitled to protection by the Witness Protection Agency, and law enforcement agencies are required to put in place mechanisms to protect the identity of informants and witnesses. Lack of protection from intimidation and harassment of whistleblowers or witnesses attracts a fine or imprisonment or both. It is now more urgent than ever that all public and private entities review their anti-corruption and prevention of bribery procedures. Entities must take steps to ensure their policies are effective in preventing corruption or bribery. By doing so, entities will be complying with their corporate governance and other obligations by seeking to protect themselves so far as possible from potential liability under the Bribery Act 2016. We hope these tips have enlightened you to personally do the right thing and consistently take appropriate action when required to. Once again, take time to critically familiarize and understand the details contained in the Bribery Act 2016. Thank you for your attention.